Hi, my name is Shaye Larkin. I am a San Francisco bankruptcy and tenant rights attorney, and one of the services that I provide to my clients on a regular basis is I help tenants get their security deposit back from their landlord when they've moved out and the landlord has taken the deposit illegally. This video is based on California law, and watching this video is not a substitute for sitting down with your attorney and getting specific advice about your specific situation. One of the mistakes I see landlords make frequently is they are charging for ordinary wear and tear, which is also called normal wear and tear. I'm going to read to you the California law on ordinary wear and tear, so wordy statute alert. California Civil Code section 1950.5e states that the landlord may not assert a claim against the tenant or the security deposit for damages to the premises or defective conditions that pre-existed the tenancy for ordinary wear and tear or the effects thereof, whether the wear and tear pre-existed the tenancy or occurred during the tenancy, or for the cumulative effects of ordinary wear and tear during the course of one or more tenancies. So, ordinary wear and tear is not something the landlord can deduct from the security deposit. And with that, what is ordinary wear and tear? Ordinary wear and tear is the gradual wearing down of things like carpets, paint on walls, and other household items due to normal use over time. The amount of time that the tenant has lived at the premises is taken into account when determining whether damage falls within the ordinary wear and tear exception and is therefore not deductible from the security deposit or chargeable to the tenant. So if the tenant has resided at the premises for 6 months, there would be a lot less wear and tear than there would be if the tenant had lived at the premises for 6 years, and that is taken into account. Here are some examples of types of damage that would fall within the ordinary wear and tear exception. The wearing down of carpet fibers and small stains on the carpet. Fading and scuffing of paint. The wearing down of a washing machine gasket. Scuffing on hardwood floors. The wearing down of porcelain on a porcelain tub due to normal use but not due to scouring of the tub. Cabinet hinges that have come loose over time. These are examples of damage that would fall within the ordinary wear and tear exception and would therefore not be deductible from the security deposit. An example of damage that would not fall within the ordinary wear and tear exception would be if a tenant has dropped a pot of coffee on the carpet and caused a large stain. In this situation, the damage is not caused by normal use, but rather by tenant negligence, and the landlord may be entitled to recover the replacement cost of the carpet against the tenant or their security deposit. However, there are some guidelines that can help landlords and tenants resolve disputes over items not falling within the ordinary wear and tear category. One such way to resolve disputes, particularly when it comes to carpet damage, is by agreeing for the landlord to prorate the replacement cost of the carpet over the carpet's useful life, with the tenant who is moving out only being charged for that portion that accrues over the remaining useful life of the item. So for example, if the tenant has poured a pot of coffee on a 10-year-old carpet, well, carpets only have a useful life of about 10 years. So in this situation, the landlord would have to replace the carpet anyway because the carpet has already outlived its useful life, and they should not charge the replacement cost to the tenant or their security deposit. On the other hand, if the carpet that the tenant has poured the pot of coffee on is 8 years old, then it would probably have about 2 more years of useful life. In this situation, if the replacement cost of the carpet is $1,000, the landlord would prorate that cost over the useful life of the carpet, so the full 10 years, and only charge the tenant for the portion that accrues over the remaining 2 years after the tenant has moved out. So $200. $200 would be that portion that accrues over the remaining 2 years. This is ordinary wear and tear. Thank you for watching this video.